About 2 years ago, I heard a recently departed US official say that the US government had tried to focus global efforts on AI regulation into the statements of principle adopted by the OECD and the G20. The former official went on to say that one goal of this strategy was to keep the EU from proceeding to regulate AI based on the precautionary principle of regulating risks without actual evidence of harm. However successful this strategy may have appeared to have been in 2019, however, the EU, or the European Commission rather, in April of this year, proposed the EU AI Act, which has been the subject of much discussion over our conference. Recent proposals by the Slovenian presidency reduced the burdens on business somewhat, but I think it's still fair to say that the act goes beyond and particularly is more prescriptive than anything the United States is likely to adopt, at least anytime soon. As one example, I think it would be difficult to sell the United States government on prior conformity assessments for high-risk AI applications. In the prior panel, Lee Tiedrich provided an overview of U.S. law. So forgive me if I, or the state of U.S. law. So forgive me if I repeat a little bit. There's certainly been increased talk in Washington of late about a federal AI statute. Most of that talk has focused on two elements: combating bias and discrimination against protected classes on the one hand, and on the other hand, controlling algorithms that promote speech that is perceived to be harmful, or to supposedly suppress supposedly, I'm saying that wrong, to supposedly suppress sort of the important speech. I still think that it's going to be years before we see any AI statute coming along the pike. Down the pike from Congress. However, in a more proximate time frame, however, this fall, the White House Office of Science and Technology Policy, as Lee mentioned, announced that it is developing an AI Bill of Rights to, quote, clarify the rights and freedoms we expect data-driven technologies to respect, end quote. And as Lee also mentioned, federal regulators, and especially those at the Federal Trade Commission, are signaling that they will use their existing authorities more aggressively to combat AI-related unlawful bias, deception, and other unfair practices. A few states also have adopted regulations targeting particular uses of AI. So what does it mean for business, for Europe to move ahead with a regulatory scheme that doesn't look, at least in some aspects, like something that the United States would adopt? Will there ultimately be convergence? Does it matter? To help us shed light on these questions, we have our panelists today. First, Gabriella Mazzini has worked at the European Commission on legal and policy questions raised by new technologies since August 2017. He designed and co-drafted the proposal for the Artificial Intelligence Act and is currently focusing on the negotiations of the proposal with the Parliament and the Council. Previously, Gabriella held several positions in the private sector in New York and served on the European Parliament and the Court of Justice. He holds an LLM from Harvard Law School, a PhD in Italian and comparative criminal law from the University of Pavia, and a law degree from the Catholic University of Milan. He is qualified to practice in Italy and in New York. Second, we've got Justin Antoni-Pillai, the founder and CEO of wirewheel.io. Wirewheel's data privacy platform leverages the latest advancements in cloud infrastructure, machine learning, and distributed computing, and addresses all phases of privacy management, including program management, data inventory, risk assessments, monitoring, and compliance reporting. Before founding Wirewheel, Justin served as the acting Undersecretary for Economic Affairs at the U.S. Department of Commerce under the leadership of Secretary Penny Pritzker. In that capacity, he led the Economics and Statistics Administration, which includes two of the United States' leading information agencies, the US Census Bureau and the Bureau of Economic Analysis. Perhaps most interestingly for our discussion today, Justin also led a number of high-priority US government efforts around privacy and security, including from 2013 until 2016, leading the US negotiating team in reaching the EU-US Privacy Shield. Justin has been deeply engaged in the issues of cybersecurity, encryption, and privacy, including on the GDPR, signals intelligence reform, and other US domestic privacy law issues, and on a wide range of other economic issues, including tax and data policy issues. He speaks regularly on data privacy and data protection. And before joining the Commerce Department, Justin was also one of my partners at Arnold & Porter, where he focused on the growth of US-based businesses and represented private equity funds and accounting firms. I should add that Justin was not the former US official to whom I was alluding at the outset of my remarks. Emily Frascaroli is our third panelist. She's managing counsel of the product litigation group for Ford Motor Company, including the product litigation, consumer, asbestos, and discovery teams. Emily also advises globally on automotive safety, regulatory, and product liability issues, including a focus on autonomous vehicles and mobility. Emily has extensive experience in handling complex product litigation matters, including those, regulatory matters with the US National Highway Traffic Safety Administration and other governmental entities in product defect investigations. She is a lecturer at the University of Michigan Law School, where she teaches a class about the legal issues involved with autonomous vehicles, and she is the co-chair of the Legal and Insurance Working Group of M-City at the University of Michigan. In 2020, Emily was appointed by Governor Gretchen Whitmer to the Michigan Council on Future Mobility and Electrification. Emily earned her JD from Wayne State University. She also received a BS in Aerospace Engineering from the University of Southern California and her master's in Aerospace Engineering from the University of Michigan. And I always feel comfortable when we've got a rocket scientist on our panelists, so thank you, Emily. Finally, we've got Dr. Sebastian Wieczorek, who is Vice President, Artificial Intelligence Technology at SAP. Sebastian's team built a platform which serves as a central vehicle for customers to manage for partners to extend AI content utilized across all of SAP's offerings. In addition, he is a key spokesperson for AI and a member of SAP's AI Ethics Steering Board, which provides guidelines on how to apply AI in a human-centric way and leads the company-wide work stream on trustworthy AI, which coordinates the execution of these AI ethics guidelines. Sebastian is a member of Bitkom's AI working group and serves as an academic expert and reviewer for the European Commission and the German Federal Ministry of Education and Research. Until October 2020, Sebastian was a member of the Enquete Commission of AI of the German Bundestag. And I'm proud to say that both Ford and SAP are Arnold & Porter clients. So to kick us off, what I'd like to do is to have Gabriela review some key features of the AI Act, of which non-EU businesses should be aware. And I should also ask that if folks have questions, we'll be trying to save some time for questions and answers at the end of the panel. So please put your questions into the chat and I will make note of them to come back to them at the end. So Gabriela, if you can review some key features for us, please.
Thank you, Peter, and thanks for the invitation. I'll share my screen, so you should be able to see the slides. Okay. Do you see them?
Now we do.
Excellent. Okay, so I just have a couple of slides just to give you a bit quick introduction of some of the most important features of the AI Act, which may be relevant for a global audience. So to start with, sorry, I think I went too fast. I'll discuss briefly the territorial and the personal scope of the AI Act. Then this concept of the risk-based approach, which we usually characterize with this pyramid. And I mentioned briefly how this is an internal market legislation, so it's based on our Article 111 of the treaty, and is a classic internal market legislation which actually has to be applied in conjunction with other internal market legislation, like, for instance, machinery or medical devices. So on the first point, which I think is really key for an international audience, what is the territorial and the personal scope of the AI Act? This is regulated in our Article 2, and the focus is on essentially three categories of actors. The first one is the providers placing on the market, so meaning on the EU market, or putting into service an AI system, irrespective of whether those providers are established in the Union or a third country. So this means that any person who puts on the market in the EU a AI product that is high risk, irrespective of whether this person is established in the EU or outside the EU, has to comply with the regulation. The regulation also does not only establish obligations for the providers, which, let's say, they could be the developers, or the manufacturers. EU legislation on products uses different terminology. Sometimes, actually, most often is used to manufacturers, but we opted this for the term provider because we are dealing primarily with software. But there are obligations not only for the provider, but also for the users. The users are those that basically have the control on how the AI system is used. And this regulation will apply also in terms of those obligations for the users to those users that are of AI systems when those users are located in the Union. And that's the second category. The third category is the providers and users of AI systems, both of which may be located also in a third country, but when the output produced by the system is used in the Union. We explain this, essentially we consider this an anti-circumvention provision. And we explain this in the recitals, imagining a situation where you may have, for instance, a company in the EU who actually is a user of an AI system, and the system is not put on the EU market, but nevertheless takes advantage of the product of the AI system, so the output produced by the AI system. It could be, for instance, an HR application or pretty much anything else. In this case, essentially, what we consider this will be sort of as the product not being put on the market in the EU, but nevertheless, it affects individuals in the EU. We think this scenario should also be covered. That being said, we have foreseen an exception for the implementation of mutual assistance mechanism as regards member states or the EU that have with third countries or international organizations, as regards the exchange of information, as regards law enforcement, judicial cooperation, because this would otherwise completely disrupt that system. I mentioned for the risk-based approach. So here, the principle is quite simple. So the higher the risk, the stricter the rules. And the idea is not much to regulate the technology as such, but specific use cases, specific instances, specific applications. So going from the bottom, there are a number of applications which we think are the majority, actually, where there is really minimal or no risk. And in those situations, there is no additional restrictions foreseen in the AI Act. The yellow layer is the situations where we think the risks are primarily linked to some sort of lack of transparency. For instance, case of impersonation or case of exposure to certain biometric categorization systems, or for instance, interaction or production of a deep fake. In this situation, what we foresee is that those systems are permitted, so they should not be subject to ex-ante requirements, but there must be an obligation for the user or the provider, depending on the circumstances, to inform the persons that may be interacting with those systems. The bulk of the regulation focuses on really the high-risk AI systems, and I'll discuss this a bit more in detail in a couple of next two slides. For these categories, what we foresee is that those systems, of course, are permitted, but subject to certain requirements, which need to be complied with in advance and through an ex-ante conformity assessment. And finally, the very smallest, really the minority of situations, there are a couple of situations where we think the risk that the AI system may pose are fundamentally unacceptable, like social scoring or like manipulative AI. In those cases, we foresee very limited prohibitions. So those systems should not be used or put on the market. I mentioned the high risk. What is important to understand is that this is a fairly overall complex architecture when it comes to the high risk scenario, but there are three main categories. I would say two main categories. The first one is divided into two subcategories, if you want. The first one is when we're dealing with AI that plays the role of a safety component of a product that is already subject to legislation. For instance, medical devices or machinery, or toys or other sort of equipment. There is a number of product safety legislation covering already these products. And AI can be embedded in those systems, can play a safety function in those systems. So if the product is subject to that, any of those products regulated by law already is subject to a third-party conformity assessment, the AI component of that product is also high risk, and is subject therefore to the requirement of this regulation. And here I said there are two categories. One are the products that are regulated under the so-called new legislative framework approach that, for instance, applies to medical devices and machinery, because there is a very similar regulatory, if you want, rationale and methodology. And those systems or those products that actually belong to what is in our jargon called old approach legislation, like for instance, cars or aviation products. In this case, we don't foresee a direct applicability of the requirements, but we actually, essentially what we do, we amend the empowerments of the Commission as regards an obligation essentially to take into account the requirements, but the system does not apply directly. There is an indirect applicability, if you want. The second category of high-risk AI systems are a number of strictly defined AI systems that are listed explicitly in Annex 3. In Annex 3, you will see a number of areas. These are the ones you see in the slide, but it's not the whole area that is high risk. So for instance, not only the whole law enforcement or migration or education and vocational training, are only those systems that are listed under each area. And in order to ensure that the regulation remains future-proof, we proposed that this is updated by a simplified procedure, the delegated acts. Now, once the system is high risk, what does it happen? We foresee a process of CE marking, as it is used in any other EU products that can freely circulate in the EU. Which means that once the system is classified by the legislator as high risk, according to the provisions I just explained briefly, so the provider has to ensure that that system is in compliance with the regulation. And so it has to ensure the substantive compliance, and it has also to himself undergo a conformity assessment procedure to demonstrate that compliance. And this can be done in two ways, through a self-assessment or through a third-party notified body, which especially is a certification by a third party. Once the conformity assessment procedure has been completed, the CE marking can be put on the system, and the system can be placed on the market. And on that basis, can freely circulate throughout the EU. So that's a bit what I wanted to say, and I stop it here.
Thank you, Gabriele. So how did the Commission staff think about the effects on non-EU businesses and the importance of harmonization with key trading partners?
Yeah, thanks for the question. That's a great point. I mean, as a first remark, this is of course an internal market legislation. So we regulate the use and the development of these products to the extent they affect the EU market. That being said, of course, we're fully aware that AI is a global technology. There is an involvement in a, I would say, global supply chain. And we are certainly working towards, as much as possible, an international convergence. Here, of course, there is the work, for instance, that is done at OECD level. To note, for instance, that our definition of AI systems, I didn't discuss that, but it's actually inspired. The definition we proposed is taken from the OECD. And this has not been by chance. This has been because we wanted also to make sure that we could adopt in the EU, for the EU legal framework, a definition of the AI that is widely shared internationally. So, but that being said, I think the international convergence, we think, will happen mostly at the level of standardization. We are aware there is a lot of work happening already at the standardization level. And we think that this approach that we have chosen, which relies extensively on standards, so-called harmonized standards, that's why we chose this new legislative framework approach, because this system relies extensively on harmonized standards, which are European standards, but those standards actually can largely be aligned with international standards. So there is a process there of convergence, which we think will certainly facilitate also the interaction with international business.
Thank you. Justin, putting your former government hat back on, how is the US government likely thinking about the European Union's moving forward with regulation and more prescriptive regulation than the US is likely to adopt? And in particular, perhaps your experience with the GDPR would be informative here.
No, first of all, Peter, thank you. And thank you to the Athens Roundtable for having me here today. Gabriella, it was a terrific summary of the AI proposal. I have a couple of quick reactions, Peter, to your question. The first is I don't see the US, as you said, going towards, certainly at the national level, a kind of approach that's framed in a similar way around AI. It is a pretty, it's thoughtful, and obviously Europe has the right, because you're dealing with European data, and because right now data is treated in such a territorially specific way around the world. This, in my view, is a perfectly appropriate way for Europe to start a very important discussion around application of AI processing to, personal data and otherwise. GDPR, if I may say, started a lot of discussions around the world with inclusion of automated decision-making within GDPR. And Peter, we all have talked about this. You see laws like the California state law adopting essentially opt-out provisions for people to be able to choose to opt out of automated decision-making regimes. And we see that kind of a mode likely to persist around the US. So I think my first observation is, while I don't see a likelihood of a federal US approved approach that's going to be passed in the short to medium or even in several year term, regulating automated or AI in the way that the EC or EU is proposing, I do think that the California approach on enabling opting out of automated decision-making is really likely to be followed in other states around the US. What we're really seeing is, in the absence of a federal approach in the US, we're seeing state after state following the California framework. It went first to Colorado and now to Virginia. And at a certain point, when you have a large group of US states adopting something pretty similar to California, you effectively will have a national standard in the US, whether or not you have a federal law. And for those of you that follow this, certainly I know Ford, you could speak to this. California did this before with some of the emission regulations in the 1970s, and it effectively resulted in a national standard on emission regulations, even though there was no national law. So I do think there's going to be some movement on AI sort of law or automated decision making in the US, but I think it's likely to be driven by sort of adoption at a state level, one after another, of that sort of framework. And then, you know, your question to me, Peter, was how does the US government react to this? Interestingly, I literally an hour ago, as part of we have our global Wire Wheel Spokes Conference today, I was talking to Bruno Gencarelli from the European Commission, one of your colleagues in another division, who's been leading some of the discussions on international data transfers around the world. Gabrielle, I suspect you work with Bruno and that part of the European Commission all the time. And there is likely to be some convergence on some of these issues, but I think my sense of it is the US government is likely to view the AI regulation in a number of different channels. It's likely to be viewed, Peter, as a trade issue. When you talk about regulating technologies as they are being offered in Europe and subjecting them to certain kinds of certification or other processes, that is a very typical kind of process that would be subject not only to, you know, a unilateral decision like the EC is stating, but it's likely to come up as an application of a country-specific regulation in an electronic trade issue. And I wouldn't be surprised if the AI Act becomes an item that is discussed in trade contexts as well. I was really interested, and then I'll pause because I think there's a lot we could talk about here, but there's effectively exclusions from the AI framework, if I understand it, Gabrielle, at the government level. Is that correct in terms of how it's applied in the current proposal? Within the within European member states?
If I may just quickly, only so there is an exception only as regards to mutual cooperation agreement in the judicial area, but within the EU, the public authorities may be also providers or users. They would apply to them equally as to the private actors.
Yeah, that makes sense. So again, just to come back to Peter's question. So one channel I suspect it'll be discussed is trade and trade issues. I suspect another channel that will be discussed is within the bilateral discussions at the national security or government sharing levels. How does a regulation like this affect the participation, the mutual assistance treaties and others between the US and EU member states? And there are obviously some pretty deep arrangements between the EU and US member states at the national security and DOJ level. So, and then of course, finally, when you see the coverage immediately, Gabrielle, at one point, it's a major move forward in terms of looking at AI from a regulatory perspective. But then immediately, I think there's also a lot of feedback that came in from civil society about the proposed regulation not doing enough. And I suspect that'll be an international discussion, not only in Europe, but also on the US side with respect to civil society.
Thank you, Justin. That was a very helpful overview of a lot of different areas where things are going to be happening both in the United States and in the government. So turning to a business perspective, Emily, how are US-based global companies thinking about the AI Act and the concerns that you may or may not have about divergence in regulation between the United States and the EU?
Sure, and thanks, Peter, for that invitation to participate in this highly esteemed panel today. I feel a little outclassed. You guys know so much about AI. what I know about is self-driving cars and regulation in the US, and that, of course, self-driving technology involves the use of AI and machine learning quite extensively. So let me talk about it a little bit in that context. So Ford is super excited about the potential benefits of self-driving cars for consumers. Things like increased accessibility for those with transportation deficits, a positive impact on the global congestion problem. And of course, you can't talk about self-driving cars without talking about the potential for improvements in safety. Part of the problem is you can't realize any of those benefits without having an appropriate regulatory scheme in place. And I think this is the trick. And I think I've heard a lot of discussion about this on a lot of different panels, is that you have to find a way where regulation facilitates and enhances innovation. And I think this is possible to do, but what you really want to avoid is a regulatory scheme that becomes a barrier. So we have to think about timing, the sort of when you do things, and the how, and sort of thinking about, are there options beyond strictly regulatory frameworks? For example, in the US, NHTSA has issued autonomous vehicle policy as opposed to regulation. I've heard others mention the White House is working on this AI Bill of Rights, which feels like one of those regulatory tools that's a little different than strict regulation. So I want to talk about timing just for a moment. And one thing that kind of gives me pause when I think about regulation of AI in the context of self-driving cars is that here in the US, we really lack a modern regulatory framework. And this is already a barrier to innovation. And we've known this for a long time. As far back as 2016, the US Department of Transportation explored barriers and challenges to certification of self-driving cars. And they've identified a number of, we have here what are called Federal Motor Vehicle Safety Standards, or FMVSSs. They identified a number of those that would be difficult or impossible to meet in vehicles that lack driver controls. So things like a steering wheel, brake pedal, and accelerator pedal. For example, just simplistically, FMVSS 135 actually has a requirement that vehicles have a physical brake pedal. Self-driving cars don't need brake pedals, and in fact, you probably don't want brake pedals in a vehicle with occupants, but 135 explicitly requires a brake pedal. So unless you are granted an exemption, you can't currently have a self-driving car at scale without a brake pedal. So it's critical to set the right public policies that will provide for the safe and competitive operation of self-driving cars, and we need to do that globally. But in my view, we need to start with making sure that the current regulatory frameworks are right before we start layering on additional requirements. And so I guess I go back to the original question about global harmonization. And I will just say, I have a lot of experience in the safety context and transportation, that having different regulatory schemes across different markets is extremely challenging. Ford and other OEMs have been navigating this in the automotive context for a really long time. And it can often result in sort of suboptimal results, product differences in different markets. It can be very inefficient. It can add to the timing of product changes, make things more difficult. Justin mentioned sort of this state-by-state approach. I'm not a privacy expert, so I'm not going to talk about that, but I can tell you state-by-state regulation of automotive safety is something we've resisted for a long time, because it can set up scenarios where you literally cannot make a vehicle that complies with requirements in one state and doesn't comply in a neighboring state. And we know that people drive their cars between states, so that's a really challenging scenario. So that's why we believe here in the US, NHTSA, National Highway Traffic Safety Administration, really ought to have the authority to set performance-based requirements. And we would say, leave other things to the states that are more appropriate state type issues like insurance and licensing and regulation and things like that. So I guess that's a long answer to a relatively simple question. hopefully I covered what you were hoping for.
Thank you, Emily. So, Sebastian, do European businesses view the prospect of disharmony between the United States and the EU sort of similarly, do you think, to U.S. global businesses, or is there a different view?
I think, yeah, obviously there's a different view if you get regulated or you don't get regulated, right? So for European companies, it's a bit different. But I think just to get the elephant out of the room, I think the AI Act is a move into the right direction. I think a risk-based approach is good. Drawing red lines is meaningful. Saying what is high risk is appropriate as well, and defining what needs to be done then. I think personally that maybe we have to differentiate a bit more about what is the public sector, what is commerce. So when private persons are touched by regulation in comparison to what is happening in B2B cases, so business interacting with other businesses. But I think based on the risk-based approach, my hope would be that the definition would this definition would push business-to-business interactions low. What I think what I'm a bit worried about, and the AI Act, of course, is in draft stage and is not final, so it's I cannot say, or it's hard to say what is going to come and what will be the details. But what I'm a bit worried about is that there are certain side effects that could happen that make it extremely complicated for European companies to be part of competition. And I can give an example of how GDPR created such an area for the AI industry. When you're a European company and you want to train a face recognition service, and there are high risk applications for that, but there are high risk applications in the definition of AI Act means it's okay to do it. You just have to fulfill certain standards, and certain applications are not okay, obviously, like public surveillance. Now, what you have to do in the EU is you have to obey to the GDPR principles, which in my opinion is the right thing to do. But what is happening if a non-European actor is training a face recognition model not obeying to GDPR? The result of the training is an algorithm that is not providing any person-related information about the data that has been used to train the algorithm, even though it was very private data that was used. And the algorithm can be used according to GDPR, in compliance with GDPR in the European market. And the result is that European companies have much more efforts, have much more costs to develop certain kinds of algorithms compared to non-European companies, and then are not able to compete. And especially in high-risk applications, what we then could see, if we don't get this regulation right, is that actually it's non-European, American, Chinese, Russian, whatever companies that are providing the solutions according to the standards that we're setting in the EU, according to the standards of applying them. But the European companies, especially in these high-risk cases, have not a chance to compete even in our own market. And I think what I would like to see is that we're very careful in what we're regulating, and that we're taking care that we're not creating this kind of situation, especially in these high-risk cases for European companies. I think that there is a lot of, I would say, in the US, when I compare it there, I would say there is no GDPR, there is no strong regulation on data privacy, and I think that's. I mean, I'm a European citizen. I'm not there to comment whether this is good or bad, but I would say that means that there is no safety net for AI regulation. So I think, in my opinion, it's quite a risk to also say we don't want to regulate AI on a federal level. We just leave it. And then see what happens if state by state is maybe doing something or not doing something. So I also agree with Emily. Even if we would do that, that would make it very difficult for any party to introduce AI software, AI systems state by state in the US, which then would, in my opinion, also have create issues for the American economy if there's not a clear guidance on where to do what. Then probably the market is shifting elsewhere, and people are trying out their innovation and building their innovation elsewhere, and not in the US, if that is what is meant to be happening. I think that the best way forward, and here I think I agree with all of the people who have been speaking, is that standardization on let's say a global level is the best way to mitigate the issues that we see in let's say keeping or creating different regulations or let's say harmonizing regulations. But I think we also have to see how these standards are applied. I think the idea that we have horizontal regulation, in my opinion, has some beauty when it comes to defining risks, but I see some issues with then let's say trying to kill everything with one set of rules, where in each vertical the situation is very different, and we have in each vertical in each industry very different regulations, like the braking pedal discussion that we or the braking pedal example that we just heard about. And I think it's more important, in my opinion, to look into all these verticals, see where are these high risk cases, and take, let's say, the precautions to make the regulations for these industries specific enough and meaningful. And I think also in this high risk approach that the EU is giving, these verticals, these industries are known, and there are it's easy to figure them out. And many of these industries, they will not even be or they will unlikely be touched by that. Of course, there's some cross concerns when it comes to HR data, but you can regulate that as well. But I think targeting the right issues, that's what I would hope is coming. And I think we're in discussion about the AI Act. I've seen that, for example, when it comes to the definition of AI system, Gabriele, you mentioned that the first version, in my opinion, was not very of the definition of an AI system was not very good. It was basically a definition of software system overall, and I was very happy to see that in the new draft this has switched to a definition that is very close to what the OECD is doing, to very close to what other actors in the past have also adopted in defining AI-based systems. So I'm also very optimistic that in dialogue we're able to get the right things in place, but also remove some of the obstacles and remove some of the risks that I'm seeing when it comes to European regulation. And I'm also hoping that in joint discussions, like in the Trade and Technology Council with the US, we come to a conclusion and there is agreement on joint standards, on joint regulations, so that we create a joint understanding of what we want, what we don't want, and how we want to safeguard the things that we see as high risk or critical.
Thank you, Sebastian. To the extent that we don't think that, or well, not to be too pessimistic, but to the extent that we think that regulatory convergence or harmonization, perhaps under the form of a treaty under the auspices of the Council of Europe, may be a bit of a bridge too far right now, at least in the relatively short term. How much do we expect? Sebastian mentioned standards as a way of achieving the same objective. What do the rest of you think about perhaps the role of standards as the gap filler, to the extent that you think that we're not headed to convergence anytime soon? Who wants to take that one first?
I'm happy to jump in if helpful, Peter. First of all, very thoughtful comments from the panel, if I may say. And Emily, I want to say, your observations on the ground when you're actually, trying to deploy, a technology like an automated car. I do think it's important that standards across the US really do need to be unified, or you really do end up with some compartmentalization that could be counterproductive on a lot of different ways. You even if you look at it from the human being, the consumer view, how are they supposed to know what rights they have in which state if they're really, really different? So I do think it's important that we have kind of a unified standard. And Peter, if I may, just one thing, just to react to Sebastian, I do think you've taken some very strong positions, Sebastian, and I like that. But I do think it's fair to say that the US does have actually a very robust set of privacy standards. And, we're the country of the Fourth Amendment. We've been protecting privacy in the national security space for a very long time. And the states are moving very quickly towards adopting standards. And in the US, a major state like California, which has a huge economy, when they adopt a standard and you have to start following it, and one could say that the combination of California laws, for example, Sebastian, is essentially equivalent to GDPR. It has a very broad reach at this point. So very few companies in the US right now sell their product and don't plan to go into business in California. And so there is a sort of standard arising in the US by virtue of these state laws. And I always think it's helpful to at least acknowledge that there are two different regimes arising. They are different in a way, but there is an important set of privacy principles in the US that do drive a lot. Peter, just to go to your question or point, standards are going to be very important in this particular area because the speed of development of AI technology is moving so quickly that if we were to just drive regulation through fixed regulations or laws, they're very unlikely to keep pace with the kind of innovations that Sebastian and Emily and Gabrielle have been talking about. You need some kind of other standard setting and expert organizations that are specialized in the technological areas to actually give guidance on what these things mean. And Sebastian, to your point, for years now, even in the automated decision-making area under GDPR, there's a lot of research just going into how do you disclose and understand what is happening in a neural network. And the only way that you can really get that kind of expertise is to have experts and standard setting organizations set some guidelines on an international basis, both at the technical level and at the policy level, Peter, to help drive that conversation forward. So obviously the risk of standard setting organizations is they're harder to have redress and enforcement on a non-legally enforceable framework. And I think that is one of the trade-offs along the way, if I may say.
Sebastian, do you feel a need to respond, or should I?
I can do that quickly. Yes, thank you.
Sure.
So I think as I explained with my face recognition example. Let's say even if there is strong GDPR-like state law in California, what does it mean? It means that you can do everything you want in the production, in the development of an AI-based system outside. You just have to take care that when you deploy it in California, you're fulfilling the requirements. And that's why, in my opinion, the obeying to GDPR just in selected areas is not helpful. I'm not just to say that I'm not an expert on American law, and I will not comment on what is possible and what's not. But saying that in one state we have stronger regulation and it's solving it is somehow neglecting that in AI you have two phases, right? You have the development phase where you build these algorithms. Then you have the deployment phase, and of course, in the deployment phase, you can retrain, and then that brings you to other issues as well. But let's simplify and say you have the training phase in development, and then you have the deployment phase, right? And what I explained for face recognition, it's something that you don't train then after you deployed it. It means that you can do compliant deployment after having, let's say, incompliant development in accordance to GDPR. And you can have that inside the US if you have in one state, you have GDPR-like regulations, in other states you don't have. And I think that's an issue for all the other states, maybe not for California.
Gabriela, I'd like to bring the question to you, that in part, how optimistic are you about the prospects for international convergence, either on a regulatory basis or, and if not, then will standards do the trick, as Justin was and Sebastian seem to have been suggesting?
I think that the conditions are there for that to happen. I mean, at least in two respects, because indeed we discussed standards, and so we specifically chose to structure the AI Act as a new legislative framework. I mean, this concept is probably only known to EU law people, but it's really a concept that it's a way of legislating whereby essentially the law limits itself to set what is called essential requirements. And all the technical specifications to implement those essential requirements are left to the standards, which in the European system, we have a European standardization system, which is fully regulated. So we have CEN, CENELEC, and ETSI that are European standardization organizations. They receive a mandate from the Commission, say, okay, I have a new regulation here on machinery. I have 5 essential requirements. Please develop standards to implement those requirements. And those standardization organizations come together, they develop those requirements. They're actually open for participation from big companies, small companies, also non-governmental organizations, so that it could be as broad as possible. And they then submit a proposal, well, actually a standard to the Commission. The Commission verifies whether the standard meets the quality expected. If that's the case, the Commission publishes the standard, the reference of the standard in the official journal. And from that moment, if a company applies the standards to demonstrate compliance with the requirements of the law, then there is a presumption of conformity. Now, these standards that are called harmonized standards in the EU are not completely disentangled or dissociated from international standards. The CEN, CENELEC, and ETSI have international agreements with ISO or with ITU. So there is a lot of conversations happening at that level. So what I'm trying to say here is that indeed the standardization tool is, if you want, built into the system already by definition, which we don't have, for instance, necessarily in other product safety legislation, like for instance, for aviation, I would say. And the second aspect is indeed this Trade and Technology Council that has just been launched, I think, with the US in particular. I mean, this is also a sign that because there is a strong interest in developing a regulatory convergence. Of course, as was mentioned before, this is just the beginning of the process. So we don't know how long it will take for the other proposal to be adopted, and we have already foreseen 2 years of transitional period, which may be changed by Council and Parliament. So I think there is enough room for thinking that by the time the regulation will be adopted and actually applied, there will be already enough space for quite a number of points of convergence, I would say.
Thank you. We've got a couple more minutes before we need to go. Emily, do you want to jump in on this or add anything else that you want to say?
No, I don't have anything to add to that. I think these guys covered it really well.
We've got a couple of audience questions then that I just want to quickly throw out. One Gabriel, one was to you about whether government weaponry or even consumer-oriented guns should be included as high-risk AI systems.
Yes. So as regards government weaponry, essentially this regulation does not apply to AI system developed for military purposes. That's a specific exclusion that is mentioned in Article 2, paragraph 3. So that's completely out of scope. When it comes to sort of commercial or consumer-oriented guns, again, first, I don't see much of the AI system as a safety component there at the time being, but that is the trigger. So we will need to have at this stage a new regulation that regulates the gun as a product, and there should be an AI as a safety component. And at the time being, there is no such regulation in the EU regarding guns. So for that purpose, it is also de facto excluded.
Next question with Sebastian, there was a reference that you made to the new draft of the AI Act. I assume that those were, that was the Slovenian presidency's set of comments from this November 22nd and 29. And I wasn't able to get the URL up during the conversation, so I can't put it into the chat, but it's available on the European Commission website. It's where I found it over the weekend. And there's a question, Emily, for you, and it's really going to be a fast one, so I think we've got 1 minute. I need to send everybody off. But for self-driving cars, where the technology will enable greater safety, that should the tech be implemented sooner, even if it's not fully developed, or should it and save more lives, or should we wait for the tech to be ready?
Yeah, so that's interesting question. I'll just say I reject the premise of the question. It's kind of like the question, how safe is safe enough? And you know, my answer is technology gets better and things change over time. So what's appropriate today, you know, 10 years from now will look archaic, right? So I think as far as self-driving cars go, car companies have a huge amount of experience. Ford has over 100 years of putting safe technology out for our consumers to use, and we have the skills and the tool set to figure out when it's ready and it's safe, and it will get better over time for sure. But no responsible manufacturer is going to put something out there that they don't judge to be safe and beneficial.
You know what? Thank you. And so you've had the last word. Thank you to all of our panelists for an enlightening discussion. Thank you to the audience who has joined us.